Thank you, Mr. Speaker, members of the House. I'm honored here to start out today's debate. Now, what we see in today's society, we see a big problem in the judicial system. Justice, law is supposed to represent. It's a set of norms and rules set by the government so to protect, and it's a social contract so everybody can follow. However, there is a big injustice in the representation of, in many cases, of criminal offense cases, Mr. Speaker. Now, because of those who have a lot of money, who can afford to buy large firms, who can afford to be a kind of large corporations, large firms, basically they have the resources to have the best lawyers for them, so that all these things, all the bad criminal offenses that they have made can simply be eliminated and they can just proceed, Mr. Speaker. And those who doesn't have those capacity are just don't get represented. We think there's a big injustice within our law system. Even my professor back in Hanyang University, a professor telling me that law is not always about justice. Law is imperfect. It's not always justice. It's about just following the set of norms that we have. Now, we see a big problem here. What we want to do is this. Regarding to this motion, this House believes every criminal defendant should be required to use government-provided defense lawyer. We don't want to set this place anywhere. What we want to do is we don't want to talk about feasibility of this policy. We want to show you if this is the way to go, if this is good value to proceed, then anybody who believes, all the countries who believes this is a good way to go should follow. So that's what we want to focus on today, Mr. Speaker. Now, I will be providing you two constructive cases, and my second speaker will give you another two. First, I will be talking about how justice should be fair to everyone. Second, I will talk about how this would benefit to society as a whole. My second speaker will come up and say how this would lead to, how this would promote the faith within the system of law. And third, she will also talk about the rights. Okay, listen. Yes.
So you're saying your way to create fairness is to place the power of the lawyer, to place the hiring of lawyers in the hands of the executive branch.
Can you please repeat that, please?
You're saying the best way to create a fair and just legal system is to place the hiring of criminal defense lawyers in the hands of the executive branch.
Well, we believe that if those are given to the hands of the executive branch, there wouldn't be unfair representation because laws will be applied equally to everyone. Everybody who commits a criminal cases will be provided a lawyer by a government sit down. Now, okay, there's an issue of, maybe they might bring up the issue of freedom of choice. However, it's not going to be an issue of freedom of choice because every single person who commits this crime are going to be subject to the same law principle. Now, they know from the beginning, if you commit a crime, you are taking away rights. Rights are never absolute, Mr. Speaker. If this is a norm, if this is the rule that the system, that the government imposes on them, then that's what you have to follow, Mr. Speaker. Now, I'm going to sit down. First, let me talk about how justice should be fair to everyone. Now, as I have said, law is a set of rules for everyone to follow, and it should be applied equally. However, although it's nicely written down on law in books, sit down, in many cases, those who have a lot of money always buys these large corporations, these large law firms, and get them to represent them. And what ends up happening is, many cases, they just get away with the crimes that they have done and just live their lives. We think this is very unfair, and that causes a lot of social injustice and unfairness. Sit down. No, sit down. So, let me give you an example. O.J. Simpson, he had the best lawyers he could get back then, and the media, most of the people were convinced to believe that O.J. Simpson was guilty of his crimes. Sit down. However, because of all the means that he had of support of lawyers, he was turned out not to be guilty. Another example, back in Korea, Hanyang, which is a large corporation in Korea, the son of the CEO of that company was charged against rapery in Korea just early this year. What ended up happening, he was represented by Kim Hanyang, which is the largest law firm within Asia, and he got bailed out as well without any criminal charges. Now, not to mention how this is injustice for society, but we also have to think about how unfair this is for the victims as well. This just gives you This just gives you an impression that those who have money can simply get out. Now, which leads to my second argument, which is about the social benefit. I'm going to just touch very little upon what my second speaker is going to say, which is that people are losing faith in the justice, in the judicial system. Like in the case of Hanyang, like in the case of O.J. Simpson, let's be frank, everybody knows that whoever has most money can basically Now, let me explain to you how this is socially beneficial in two levels. First, about the citizen. Now, all these large firms around the world are representing rich criminals, and they are chasing those money. Now, if you have a set of law that this allows law firms to represent these kinds of criminal activities, then, Mr. Speaker, the law service prices, which is always skyrocketing because they're only just rich people, is going to put a stop. Now, it will benefit the citizens themselves, because now that the lawyers have to look for other means to practice their laws, there will be more availability for the citizens as well. Also, for the law firms, Mr. Speaker, they're always the law firms. Many law firms, such as Kim and Johnson Dow in Asia, are always blamed that they're basically big smart lawyers who are only representing rich people, even though they're criminals or not, or they're puppets of these criminals. That's what the image is for those law firms. Now, if you have this set of law that this allows them to represent them in the first place, then they can go and proceed what they were supposed to do, represent justice and continue and practice law, Mr. Speaker. What have I told you about today? I told you that there's many problems in today's law. There's unfairness of representation within the judicial system around the world. And law is not necessarily reflecting justice to the people, Mr. Speaker. I also told you how justice should be fair, and also about how this would be socially beneficial for both the citizen and also the law firm. A second speaker will tell you further, extend this debate about how this would increase the faith within the judicial system, and talk more about the fundamentals of rights, Mr. Speaker. For these all reasons that I have stated here, thank you.
I thank the gentleman for his address, and now I call on Nicholas Chung-E Ohai to open the debate for the opposition and Swinburne.
Prime Minister came up here and proposed us a solution to a problem whereby he thinks that there's injustice in the judiciary system. He thinks that there is a loophole whereby the rich criminal suspects actually are able to have private lawyers to represent them and to treat them of charges. Now, in the way that we from our bench, we see that that is not the case here. With all the kind of arguments that they have come up to us here, they have been making one big assumption, whereby they think that these criminal suspects are already accused of their crimes. Now, on this issue here, we need to have a clearer view of it all. From what we see, O.J. Simpson, Michael Jackson, and whatnot, all of these, they have been given an unfair media trial. What they have come up here and proposed to us today is just that instead of upholding the independence and the fairness and equality of the judiciary system, they have been making a mockery of it all. They have been unfair to the criminal defendants, they have been unfair to the private law firms, and they have been unfair first for to the law itself. No, thank you, it's still too early. Now, what kind of assumptions have they made so far? They assume that as long as they are being charged of the crime, they are already guilty. But what's the essence of law? It's believed that every person is not guilty until they are proven so. And under such circumstances, they are supposed to be able to represent themselves. And under any circumstances should they be have their right taken off and taken away and have someone in place for them to help defend them instead of who they feel comfortable with. Now, the point that I'm going to make here today will be, first of all, the importance and the power of having an independent judiciary system, and second of all, is how it actually helps out and actually in the economic system of the nation if they actually do not require them to hire a government defendant. And my partner is going to talk about how it will be a greater good for the nation and the judiciary system if we actually do not require them to hire a government defendant lawyer. Now, first, what kind of issues have been raised by the Prime Minister so far? First of all, we talk about how justice should be upheld and how it will actually create social benefits for them all. First of all, on the issue of upholding justice, who they feel most appropriate to represent them. Yes, sir.
Why would it be unfair? Because all those people will be represented equally by the government.
Now, you see, it's the idea of whether or not they feel comfortable with the government lawyer defendant, or they also feel that they have confidence to best represent them in court. That's being fair. Now, on what's more, they keep on highlighting these issues, whereby they already call them criminals and whatnot. But all of this has just been a media trial given to them. This is the most unfair way of treating a person, whereby they are already, their reputation are being tarnished by the media and the public just because of the charges that are made against them. But then again, please note this, they have not been proven guilty. So we should not call them criminals yet. Now, let's not talk about the social benefit. How to actually benefit the society if they actually have government defendant lawyers? Now, take a look at this. They keep on give us a misinformation whereby the poor are not defended. Then again, we know that the poor, as if they are poor and they cannot afford to hire a defendant lawyer for them, then the government will step in and uphold its duty by giving them a government defendant lawyer. But they are not required to have one if they are capable of hiring one whom they think can best represent them in the court system. Now, moving on to my first point on the importance of having an independent judiciary system. Now, take a look at it all. The independent judiciary system is just a check and balance between the executive branch of any democratic country. And in such cases, we see that they must be independent of each other. So, what if you have a criminal suspect that is being wanted to be nailed by the government? Under such circumstances, would there be fairness and equality for them? How can the public actually have a confidence in the judiciary system, whereby it's not actually independent of all the other branches, the executive branches, as well as judiciary branch? When under such circumstances, the government actually have control on who can represent the person, who cannot represent the person. Under what kind of circumstances should the government be given such power? And in such any country, the law is to be upheld. And to uphold this law, who are the best ones to do it? Obviously, those are the lawyers and the judges. And of course, the people's belief in the law. Yes, ma'am.
The judicial branch will still be independent because the judicial branch will be the ones who are making the final decision about implementing this plan.
Even if it is even if they said that it is independent, what's the public's perception of the judiciary? Would that be fair? Would they actually have the confidence in the kind of penalty passed against them, the kind of trial? Would they have confidence in the results given? Because these lawyers have been hired by the government. They can always say that the government wants them to be actually caught, wants them to be persecuted for this crime. And therefore, the public's perception towards the judiciary is no longer there. Once you actually have no public confidence in the judiciary system, it's no longer a law. Because the law is just words, and it's the people's belief and confidence in the law and adhere to them that actually keeps it up. And that's why the people are actually willing to go on and actually uphold such laws, because they believe in it. Now, what's more, we say that if you actually take away such rights from them, then you're going to take away their rights from getting a defense lawyer who they can best represent them. So what if they are too rich and get good at private law firms? Now, that is their right. They have the resources, therefore they can hire such lawyers. Now, moving on to my second point. If they actually take up such a step, it will have adverse effect on the nation's economy, because it will create a multiplier effect, whereby first of all, you know that these private law firms will hire private investigators to collect more information and gather more evidence on to help them out with the trial. If you take this factor away, definitely you cause a lot of job loss. And in turn, these private law firms will actually create more job loss, and there will be more unemployment in the country, and that is not beneficial to anyone. And thirdly, in such a case, the multiplier effect will go on to affect other industries that are related to the private law firms. In such way, such a kind of policy whereby it has adverse effects on the country's economy should not actually be proposed at all. Whereby, first of all, it's going to erode the public's confidence in the judiciary system, and secondly, it's actually going to triple the country's economy. In such a case, we are proud to oppose the case that has been proposed by them today. Thank you very much.
I thank the gentleman for his speech. Now I call on Park Soo-mi to continue the debate. Hanyang.
Thank you, Mr. Speaker and members of the House. Now, the opening government is very proud to propose this motion because we believe that under the Constitution of the United States, everyone is created equal. And under the legal system of the United States, everyone is equal. But we're seeing that in the status quo, everyone is not treated as equal. If you are R. Kelly and a famous celebrity and have enough money to afford an expensive defense lawyer, you can get acquitted even if you are guilty, and you can get lawyers for, you can get, well, so-called more qualified lawyers than as compared with people who are living out dirt poor out on the streets and got arrested for drug dealing. And we're saying that this status quo is unfair, and this is what we're trying to change from the opening government. We say that if we give equal and exactly fair, same chance and opportunity to get an equally qualified defense lawyer from the state defense lawyer's office, then we say that this is going to bring about much more fairness to the legal system, the criminal justice system in the United States. Mr. Speaker, please sit down at this point. So this is why we have proposed this, and we are going to argue for this throughout today's debate. Now, I'd like to tackle some of the arguments coming from the opening opposition. First of all, he came up here and talked about how it is unfair what we're proposing because they don't believe that certain lawyers in the defense attorney's office can best represent the clients. There are a large number of qualified lawyers in the defense attorney's office as well, and we are saying they are completely undermining the qualification and the legitimacy of the lawyers there. So we say that, in fact, if we make it a requirement, the state will have an incentive to even improve the qualities of the state attorneys and the defense attorneys so that it will improve the system in the long run. And secondly, he was also worried about that if we go with this policy and if we go with this value, then the independent judicial system will be undermined. Well, first of all, we see that if the executive sometimes feels like it is what's best for the judicial system, then they should make that decision with consent of the judicial system as well. It is not only the executive decision that's going to arbitrarily make this decision if this happens, and they're going to have full consent and full compromise and negotiations with the judicial branch as well, Mr. Speaker. However, we don't see that this is even an issue because we say that this should happen. We believe that on a principle level, that fairness should be implemented in the justice system, and this is what we're proposing today's motion, Mr. Speaker. And lastly, the opening opposition came up here and said some people in law firms are going to lose jobs. But as I will further elaborate this in my speech, if we make it a requirement for defense attorneys to defend these defendants, then there will be a rising number of the lawyers that are being hired from the district defense attorney's office. So we see that the demand and supply chain of the lawyers are not going to be hugely affected because there's going to be a higher demand that's created in this new area, and we say that this is deemed legitimate. Yes, ma'am.
Don't you think that it's slightly problematic? Your problem seems around celebrities. The problem on the opposition side seems around people who are going through the criminal justice system. The things like sedition, the things like speaking their mind, and that corruption and potential bias.
When we mentioned the celebrity like O.J. Simpson or R. Kelly, it was to clarify the examples of certain rich people out there who has more capacity to hire a lawyer. But that's not the main point of our arguments or of this debate. We're focused on the fact that there are poor, dirt poor people out there who can't even afford a good enough lawyer. And on the other hand, there are people out there who are millionaires and who can just hire 6 lawyers at one time, who's going to work much more harder and much more vigorously to actually get that person acquitted. And we're saying simply that this is unfair. Now, to move on to the constructive side of the government, Mr. Speaker, I'm going to first of all talk about how what we're proposing is going to increase the faith in the system, and overall it's going to increase the system itself. Secondly, I'm going to talk about the rights of the defendants. Now, first of all, we believe that if we make using state defense attorneys a mandatory thing, then it gives the judicial branch an incentive to improve whatever flaws or problems that there may be in the defense attorney's office. Now, I cannot guarantee that the defense states of the office of the defense lawyers are perfect. They do have flaws and they do have problems and they do have budget problems and they are underfunded every year. But we say that if we make it mandatory, then they're going to be able to get more money from the executive branch and they're going to be able to not only raise the pay for the lawyers and give incentives for more lawyers to join the office, but they can also raise the number of lawyers that they hire, assistants, paralegals, and basically bring more qualified lawyers to the office. And we're saying what we're proposing is going to lead to this eventually because it naturally creates an incentive for the judicial system to not only raise the number of lawyers, but also the quality as well. It's made mandatory for every single defendant that walks through the courtroom. And furthermore, we believe that it can improve the people's faith in the system. Because some people in the United States have low faith about the penal code or about the criminal justice procedure in the United States. But if we make it fair for everyone, if we make it fair for the poorest person on the streets smuggling drugs and getting caught, and make it fair for even the president who is committed a crime and brought into the courtroom, let's just say for example, then we say that we can create a more faith-based system where people of the United States have a faith, the strongest faith for the system. Now secondly, we believe that what we're proposing in today's debate is upholding the rights of the defendants. Now under the law, under the Constitution, it states that everyone is created equal and people should be innocent until proven guilty. But we see that in many of the cases, it's impossible for a person to we say relatively, it's unfair for certain people to be able to hire like 6 lawyers at one time and be represented everywhere and try all these kinds of dirty tactics to make sure that they're acquitted even if they're guilty, while other people get relatively poor qualified lawyers as compared to the 6 lawyers that the richer defendant has. And we say that on this case we can see that innocent until proven guilty is not applied to everyone as fairly, Mr. Speaker. We believe that in today's debate it's about which side is bringing fairness to the system. And we say that if we want to uphold the rights of the criminal defendants, then everyone should be treated equally, whether you're rich, whether you're poor, or whether you're famous or not. We believe that the law should be blind to all those things, and the law should treat them equally. This is why we are proud to propose the motion. Thank you.
I thank the lady for her speech. And now to continue the debate for Swinburne, I call on Paul Dillon Lim Young Lee.
Before I explain more on the greater good that this would bring, allow me to clarify a few issues brought forth by the government's communism stance. Now, first of all, was their assumption that private law firms only work for the rich. Now, there is no justification whatsoever that, oh, okay, you can just discriminate and just fling this group of people right where, okay, you are private and you work for the rich, and not only that, you work for the rich criminals to get scot-free. Now, where is proper justification of this part of the judiciary? Now, private law firms are also law firms. These are not private parrots or anything. These are also law firms. It is their values that matter. And then again, they talk about equality. Equality in the sense that no matter who you are, you shall be given the equal rights to obtain a lawyer of similar caliber. Now, as my partner has already explained, public figures like the absolutely tiny sample space that they gave are given media trials. And before anything has happened, the media has painted whatever picture that they want to paint on these public figures. And therefore, is it not their right to have a better caliber lawyers? Yes, answer that.
The reason why only rich people can afford the private law firms is because they charge $200 per hour. Can poor defendants afford that? We say no.
Now, you say that yes, perhaps the rich can afford this, but as I said, are private lawyers currently supporting the rich? Are they not also for justice? And also the poor. Okay, that will be. I'll come to that later about the difference between rich treatment and poor treatment. And in my third rebuttal, I'll talk again about equality. Well, you see, you are talking about equality, but yet you discriminate the variety of views by all citizens. One may have a view that, government defense, government lawyers are better. The other may prefer private law firms. Now, you are discriminating them and you are denying them this chance to actually make a basic choice of justice, of which their judgment and their discernment will decide for them. This is just a basic violation of human rights. And again, they just pin it on, poor people that can, yes, they say poor people can only get, government lawyers because they are poor and cannot afford that. And now we go on to say that, okay, because, we have some complications here. The poor people are not getting what they want. So therefore, everybody should not get what they want, and the rich we shall put into that category as well. Now this is absolutely absurd. And mind you, that is the value of currency, and that is the value of why people work hard to get money, and why people survive, and their level of survival will determine their levels. It's directly proportional to their levels of justice and how they can obtain the optimum service they would. Yes.
Are you saying only rich people have justice, sir?
Well, the problem here is that poor people cannot have justice. And you're suggesting that because of that, rich people cannot have justice too. We are saying that, okay, if you want both to have justice, your proposal would be for poor people to have a right for private lawyers. But here we are talking about whether rich people have the right to go with private lawyers. Now, okay, then again, they say that if a criminal is acquitted by unfair means by the judiciary system, that is a flaw of the private sector. Yes, that's what they said. But the flaws of the judiciary system is really focused on the collection of evidence, the careless collection of evidence, the flawed investigations, not done thoroughly enough, and all that. The judiciary is working under a basic judgmental logic, and here they are saying that no, we don't blame the actual system that the lawyers have to follow, the actual laws that the lawyers have to follow. We blame the caliber of the lawyers. Now, speaking skills and whatnot, okay? Speaking skills, the law is written in such a way that speaking skills, whether you are eloquent enough or whatnot, that is, if the law is wrong, the evidence is wrong, you are guilty. If it's not, you are not guilty. Now on to my point. On the greater good, I'll touch upon, a slight element of utilitarianism, a slight element of freedom of choice, and also we shall look into the stakeholders here, which is, first of all, the criminal. Now, if the defendant is a criminal as claimed, as assumed by the government, and Ronald Scott's three wishes, it is entirely unfair. Only the rich have the power. Now here in the criminal stance, you're actually merely discriminating the poorer criminals. Now here there is an unfair and inequality between the guilty.
lawyers, well, actually, again, it violates the right to choose. In fact, not only the right to choose by the defendant, but by the lawyers. Now, do you want to work in a government firm or a private firm? Which do you want to earn? Now here, if everybody needs to get represented in the government sector, how are they going to make that choice, and how are they going to make the living that they want? We believe that, well, they may be rich, but even the rich have rights. You cannot deny that, unless, of course, you're introducing a form of communism into the house. Now, and well, this highlights the political stance on equality. Now then again, rain falls on both good and evil, and that's why when you work hard and you earn more, then you are capable of getting what you deserve. And when you are poor, the government even provides a means to get that justice by providing you with government lawyers. Thank you.
The speaker for Australia takes 23 seconds.
I thank both those teams for their presentations, and now we turn to the lower part of the House, and I invite Winston San Yin Chu to begin the government presentation for Hong Kong.
Ladies and gentlemen, members of the House, what have we heard just from opening opposition? We have heard a very Machiavellian speech. What has he told you? That if you're poor, you don't deserve justice. That's why you should work hard. So you have the presumption of innocence, so that you have a right to due process. But what the government on this side says is that due process and the presumption of innocence is the constitutional basis of every legal system. And that one of the most contentious issues within this reason, as my opening has already told you, is that rich people are able to get private lawyers who might spend trillions and billions and thousands of dollars to just get them off the hook. And what we say is that this is truly this dichotomy between the rich that are able to get private lawyers and the poor, which are just able to get the government-appointed lawyers, is against the principles of justice. And what we say is that the government-appointed lawyers are going to be more independent, more fair, and more accountable. And that is the extension for us today. And that is what the extension is, three-part, which I'll delve in. The first thing is, what is the incentive of the government to appoint independent lawyers and to be independent in this prosecution? Secondly, what is the incentive for these appointed lawyers to be independent? And thirdly, how this will all increase in a better system where the public has more faith. No, sir, later, please. Now, on to my first point is the incentive of the government to be independent. What the opposition at first tried to say was that the government will have so much power that will try to swing the judicial system. That will try to affect the judicial system because it has the means to appoint which lawyer. So then, for government enemies or for certain points where judicial review might be initiated, what they contest is that the government will appoint really bad lawyers. But what the government says today is that what we will do is that the appointment system is a bureaucratic system, not a political system. What did we see today when the poor get their lawyers appointed? They're appointed on a bureaucratic basis. No political influence, no political factors is put into this appointment. And that is, there is an independent appointment system which is free from the political executive. And this is why. Because what we see is that lots of power is given into the government, and that the power of who to prosecute is given into government. But we do not see that the government only prosecutes its enemy and doesn't prosecute the people that it likes. Because why is it? Because we have administrative law, we have a bureaucracy, an independent bureaucracy who is part of the executive, but acts on a favor of the people. Yes, sir.
There's no independence if those lawyers actually depend on the government for their salaries.
Sir, I will delve into that point exactly, which is for the second stage of my extension. Now, as I've told you, the separation of power, administrative law, and bureaucracy really protects the government in appointing, in its appointment, it acts independently and does not act from political factors. Now to the second point of my extension, which directly addresses the opening opposition's POI, is that what is the incentive of the lawyer to be independent? The opposition has tried to tell you that the lawyers will just lose the case on purpose just to appease the government. But what have I again and again told you? That this is a bureaucratic system, that remuneration is merit-based. Obviously, lawyers that have won more cases, even though if it's against the government, are going to be paid more than the ones that have lost all the cases to the government. Yes, ma'am.
How many bureaucratic systems are there actually out there? You're saying how many bureaucratic systems with administrative justice that works nice and fine and dandy are there out there?
Ma'am, what we see is that exactly the case I told you about prosecution. Do we see the prosecutors only prosecuting government enemies and not prosecuting government friends, not prosecuting government allies, even if they kill and murder? No, but what we see is that our prosecution would even prosecute its own members, that it might prosecute certain ministers and as deputy ministers for corruption. And what we see is that this is the perfect example of the independence of the bureaucracy. And that is that the lawyer, in knowing this the independence of the bureaucracy, will act on its own rational calculus. And furthermore, even if the oversight of the bureaucracy is not enough, there's also an independent check on the independency of the lawyer, and that is the Bar Association. All lawyers must be under the bar, and the bar creates immense power on who can be a lawyer and who cannot be a lawyer. Certain defendants that have thought suspect that the lawyers have defended them unfairly can lodge a complaint to the Bar Association or the certain relevant authorities in various countries to see them whether the lawyers have acted reasonably and acted in the full command. So what we see is that if what the opposition asserts really happens, that lawyers really do argue cases so that they lose it automatically to the government. What will happen is that the defendant can go to the Bar Association, and if it is substantiation, the Bar Association will debar the lawyer. So what we say is that the lawyer has a perfect rational calculus to act in the best interest of the defendant, whether rich or poor. And as I've said, that because as and over again, that there should be no dichotomy, because that first of all, there should be no distinction between rich or poor, whether they deserve the presumption of innocence, and secondly, because a government appointed lawyer is as independent as a private employer. And lastly, onto my third point, is that it is increased faith in the system. What we see in today's system is that the public system is with bad lawyers, because all the good lawyers go into the private system. They get thousands now, and what we see is that if there is only one system, then the good lawyers will also be in the public system, and then there will be no bad public faith. Because why does the public have bad faith in the government defendants? Because they're all the good lawyers are already in the private sector. And when we only have this one sector where everybody is government appointed, there will be all the good lawyers will stay there, and that people will have good faith in them. And so for all these reasons, the reasons that the government has an incentive to be independent, the lawyer has an incentive to be independent, and thirdly, it will overall increase the faith and the quality of the defense. For all these reasons, I beg to propose.
I thank the speaker for that presentation. Now I call on Alison Dunn to open the debate for Auckland.
We've heard a lot of warm fuzzies here in the opening half of the debate, that everyone's going to get equal justice, that it's going to boost public confidence and public morale all round, that there are these fantastic bureaucratic processes and systems that are already in place. In what country? Well, I don't know, because they didn't give me one. That even if that doesn't work, there's actually an independent check there. And we have seen no analysis of this at all. All we have seen in this debate is mere assertions that there will be equal justice because lawyers will only come from the government. And what I'm going to prove to you in this debate is that their proposal doesn't actually achieve this. But I'm going to go further than this, and I'm going to show you that their proposal actually worsens the current situation. We heard at the start that they don't want to deal with practicalities on the government side. ideas for the closing opposition. Firstly, I'm going to talk about the right to a fair trial and what we see this as on closing opposition. Secondly, I'm going to talk about the idea of freedom of choice, and freedom of choice to choose what lawyer you have, maybe for ethnic reasons, maybe for religious reasons, maybe for other reasons. We're also going to look at the quality of lawyers that you're actually going to see when they're being employed by the government. Then I'm going to have a look at the dollar signs that we see in terms of, well, O.J. Simpson and Michael Jackson, well, they have an unfair advantage. So that's the problem in the debate today. Then I'm going to have a look at the judiciary versus the legislature. Why we see that separation of powers is a good thing, is a healthy thing, and is something that we should be encouraging. And then I'm going to have a look at where the executive is somehow going to get all these extra dollars to employ not only the lawyers for the Crown, but the lawyers for the defence, because I don't really see where this money is exactly coming from. And could the closing government please tell me where it will come from? So on to the idea of the right to a fair trial. What we see is that the right to a fair trial involves no bias. And we see that bias, there are two types of bias that you see in the judiciary today. You see presumptive bias, which is based on financial gains that can be gained from being biased. And what we see is that these defence lawyers will have this presumptive bias. Their salaries, their life earnings will be coming from the salary and the wages that they will be paid by the government. So they will have that incentive there not to get fired, not to lose their livelihood, so they don't have a job, so they can't eat, so they can't provide for their family. So we can see that this presumptive bias is apparent. The second type of bias is apparent bias, and this is bias through a relationship. And this relationship comes through the relationship of employment, that they are the defence lawyers' employer. And we see this as a serious conflict of interest that we do not support on the closing opposition side. So what we see is that people who face charges of sedition, people who are involved in protest, people who are expressing their own views that are against the views of the government, which is a huge problem that we see today in society in places across the globe. We see it in places like China, we see it in places like India, many different places we see this problem. And what we see is that well, these defence lawyers aren't going to actually be neutral. They will have this bias present. So moving on to my next idea of freedom of choice. We think that they should have freedom to seek private legal care. They need to seek legal care from someone who actually believes them, who actually believes that they are innocent, because this is important in having a lawyer, because they can present the best case possible, because they believe you, because they're not doing it in terms of hard effort. Secondly, we think that it's important to have freedom of choice to choose a lawyer that maybe has your own ethnic values or your own religious values, because in terms of defence, sometimes you can have, you can have an ethnic or a cultural reason of why you behave or acted in a certain way, why you had that sort of reaction to that situation. And by having known that, a lawyer who understands this
I thank the speaker for her address. And now I call on Wu Tiffany Tak Yun to conclude the debate for the government side and for Hong Kong.
That's very, very funny, because what we're saying on this side of the house is that it's not fair
application process. Everyone gets the same chance of getting a good lawyer. Everyone has the same representation, ladies and gentlemen. And secondly, we have, as my partner has already told you, we have the Bar Association to ensure code of conduct. If a lawyer is not doing his job or her job, then there is a system, there is a mechanism for the victim to report him or her. For that, yes.
Yeah, how can a bar system be independent when she's directly associated with the executive branch?
Sit down. I will go to that later on separation of powers, ladies and gentlemen. So secondly, on your second problem of employment bias, which is kind of absurd also, because you say that because the government employs them, because the government employs them, these lawyers are going to do what the government wants, ladies and gentlemen. Firstly, the job of a lawyer is to defend justice, and whether appointed by the government or not, who gives this money is not the point. If this is so, let's assume that what you say is true. If the government employs these lawyers, then the lawyer will do what the government wants. We say that under your model, under status quo, right now, this employment bias only applies to the poor people, because right now only the poor people have lawyers employed by the government. So we say that employment bias exists under this system for the poor people and not for the rich people. And you say, is this fairer than what we propose? Do you want more employment bias or less employment bias, ladies and gentlemen? So we say that even if there's employment bias, we say that under our model, under our system, it is fair for both the rich and the poor, the guilty and the innocent. So I also want to talk about the independent bureaucratic system, and this is also something to prevent actually bias and having less competent lawyers. And we say, give us 3 examples: Hong Kong, France, and UK. Easy. 3 places have, at least 3 cases, have independent bureaucratic systems that are very fair, are very just, and are independent from the executive and judiciary system. So under these 3 reasons today, we are very proud to propose.
I thank the lady for her remarks. I now call on Alex Nelder to conclude the debate for Auckland, and in fact, to conclude the debate.
Key questions that the opposing opposition would like to ask. Of the 2 systems that you've heard here this afternoon, what system is going to best provide for a just and fair system? The second question we have is that what will best provide for a system that upholds the rights of criminal justice, the rights and freedoms of criminal defendants and criminal defendants. And on both rounds of the debate, closing opposition has provided a reasoned analysis of why taking the most independent part of the criminal justice system, the criminal defendants' lawyers, and making them into some centralised part of the executive branch is fundamentally a terrible, terrible idea. So let's first take a look at the opening half of the debate and what we heard from the opening government. Because what they came out, their entire analysis was based on the fact that law should be applied equally. And they used the examples of OJ, and they used the examples of Michael Jackson. And they kind of gave us these examples of these large-scale CEOs having better access to better lawyers. Basically, what this sounded like is that they were proposing a worse standard of justice in order to have what their conception of a more equal standard of justice. Because they conceded, both at opening government and at closing government, that the government is, by its nature, as a public service, unable to provide justice to criminal defendants at the standard and quality of lawyers that could be provided by the public sector. And we stood up here and we said, where is your money going to come from to provide a good standard? One of our extensions was to stand up here and say, how will you get the money to provide a good standard of lawyers? And their response was to stand up and do nothing, ladies and gentlemen. But that's the crux. That's the crux, ladies and gentlemen. No, thank you. When their analysis only goes as far as, well, maybe it's okay to have a lower standard of justice if every criminal defendant has the right to this lower access. And we say this is fundamentally a poor point, and it's largely rubbish. Because you need to have the principle of competition apply, which was another arm of our extension. If the government has the monopoly over defence lawyers, there is no competition. So we raise the point of where does the money come from, and we also raise the point of where is the incentive to have a better standard of law than your current system of legal aid. In fact, scratching the surface of analysis one more step, you disincentivize the government to provide better quality lawyers. And soon this will segue into the second half of the debate and our important question of corruption in the governmental systems. You provide a disincentive to the government to provide better quality lawyers because you end up with a Crown prosecutor, no thank you, a Crown prosecutor, ladies and gentlemen, versus a Crown defence lawyer. And who does the government want to win? The executive branch, their police forces and their legislative laws, or the criminal that at the moment has gone outside and broken these laws? Ladies and gentlemen, the law is a funny beast and justice is a funny beast too. And in an impartial courtroom, justice normally wins out if you have all elements acting impartially. Yeah, wouldn't you agree, ma'am?
No, we don't. And sir, we don't understand why the money is such a big issue, because when a government decides to do something, in this case, let the state defense attorneys defend these defendants, then they'll set aside an extra fund from the taxpayers' money.
But why would they? No, I'm sorry. You've had your chance. Why would they when there is no incentive for them to do so? Because they have the monopoly over all the defence lawyers. They don't have to compete. Their prosecutors don't have to compete against other lawyers. And secondly, you disincentivize them to provide better quality lawyers. Where is the incentive and where is the money going to come from? The government just doesn't suddenly acquire more money to set aside, ladies and gentlemen. Let's now look at the second half of the debate. Let's look at their extension, which was basically to stand up and try and prop up a pathetic model from the opening government, which was for some reason a bureaucracy would now be able to hire the lawyers. First of all, this was not something raised by the opening government. It was an extension, a fundamental extension to the model which came out in the close, which said that a bureaucracy will be able to hire it, therefore it's all well and good. We challenge them to say not every country has this system of an impartial bureaucracy. And even if you did, all these other wonderful things you talked about, all this administrative justice that you spoke of, well, in order to have that, you need to have an impartial system all the way through. And they have conceded the point that it will be impartial, ladies and gentlemen. So let's now take a look at our extension. Let's now take a look at the rights of people to a fair trial and the rights of people to be free from corruption. Because we were the only team today, ladies and gentlemen, that has stood up and focused on the specific crimes that the legislature has the full right to make, which are crimes of civil disobedience, which are crimes of sedition. Ladies and gentlemen, the legislature can make any law it wants. That a legislature in democracies can make any law it wants that fundamentally goes against the rights and freedoms of individuals to have freedom of expression, the right to impart opinions of any kind in any form at any time. And we said, how can you guarantee a system where the lawyers are being beholden to the will of the government, where we brought up in our extension the fact that they're in an employment relationship, that there is bias because they are reliant on employers to have their job, to keep their jobs. How can you guarantee that all of these things will still apply? How can you guarantee that there will not be corruption in these states? And that was not addressed by the government side of the House today. And it sort of segues into the theoretical underpinnings of the closing opposition's case, the idea that you have to have a separate judiciary and a separate executive. Because, ladies and gentlemen, the job of the executive, ladies and gentlemen, is to, and the legislature's job is to make the law. The job of the executive is to enforce the law, and the job of the judiciary is to interpret the law, ladies and gentlemen. So the judiciary is the only one, based on that the reasonable conception of it, is the only one that is looking out for the rights and freedoms of individuals, ladies and gentlemen. And when you don't have the impartiality of defence lawyers, when they are not standing up and making the best possible case that they can, because either they're not the best lawyers, as we pointed out, because there is no incentive for the government to provide the best lawyers, or they're being beholden to an employer relationship, ladies and gentlemen, that means they're not trying their best. When you have this happen, when you stand up and you have the judiciary providing, you have defence lawyers not putting forward the best case that they can, then you have the executive not only being able to interpret the law, being able to make laws that go against the rights and freedom of the individuals, but then they also have far too much power in interpreting the laws to go against the rights and freedoms of individuals. Ladies and gentlemen, what you've heard today is a cost-benefit analysis. The costs of being on their side have been O.J. Simpson and Michael Jackson, and whereas the benefits have been the fundamental things of the separation of powers and not having bias in the judicial system and having a better standard of lawyers. Flip that around, you have a terrible standard of lawyers, you have bias and corruption in the system, and ladies and gentlemen, we fundamentally think that is why this debate must